side, part 11 of the we'll be discussing right now center state relations, the last topic under the public administration side, part 11 of the Indian Constitution. And what better photograph than this, the amazing bond that these two great leaders share, right? The center state relations. Okay, so let's begin with our very first topic. And the center state relations are basically categorized along three lines: the legislative relations, the executive or the administrative relations, and also the relations with respect to the financial matters. So, first up is the legislative relation. And in that, we need to know what are those areas. See, I don't think I need to explain Article 246, right? And Article 248. All of you, I'm sure, would be aware of these two articles. Article 246 talks about the list, the Schedule 7, the three lists. And Article 248 talks about what? It talks about the residuary powers, meaning topics which are not mentioned in any list. They find a mention in the which list? Or no list. They are called residuary remainder parts, and center controls these parts. Anyway, see, yesterday we were discussing certain areas where the center has the power to make laws on stateless subjects. One was Article 249, which we have seen earlier as well. Article 249 allows the parliament, allows the Rajya Sabha to authorize the parliament to make laws on stateless subject. Simple. Second is Article 250. This is the one that during national emergency, the parliament can make laws on stateless subjects. The state list tends to behave like the concurrent list where both have the powers to make laws. We saw this yesterday. Excuse me. Now, beyond this, there are two other ways in which the center can make laws or the parliament can make laws on stateless subjects. One is very simple. If at any point of time, two or more states come together, pass a resolution, and ask the state center, please make laws on these topics for us, then in that situation also the parliament can make laws on state list subjects. Tejaswini, am I not audible or what is it? Sir, I am not getting you. Audible or topic is difficult? Anyway. So, I'll give a simple example. Public health. The matter of public health is a stateless subject. This is entry number 6 in the state list. Meaning, on matters of public health, states have to make their own laws. It's a stateless subject. But states like Sikkim, Himachal Pradesh, Arunachal Pradesh, and even Mizoram, these states collectively told the center that, center, please make laws for us on how to manage the hospitals. And center did make a law for them The law is called clinical establishment. What is a clinic? Hospital, clinic, clinical establishments. Registration and Regulation Act of 2010. This is an example of a law made by center on the state list subject for a few states. So this requires two or more states to ask the center, right? At least two states. That is the criteria. So no other option here. Now, in future, any other state also can ask the center that center, I also am okay. I will also use this law. That's possible, of course. Giving up your power is very easy. The whole point is, can the uh, center make laws or not, encroach upon the state's functions or not? Yes, it can if the states allow. So this is a situation where the states are allowing the center, please take this subject and make laws on that topic. Okay. Now, uh, center can, of course, parliament can make laws if the states request. Parliament is not bound to make laws. It may not. It may say, no, no, I am not interested. Sorry, I have bigger things to do. I have to abuse my fellow members also. Sorry, please. So that may not be possible. And the laws made are not applicable to all the states. It is only applicable to those states which have accepted this. Why would other states be involved here? Are you clear? Everybody? So only those states which have approached, the law is applicable to them only, not to other states. Simple. And one more thing. See, center controls lot of topics and areas. Sometimes for and center also goes to various places and signs all these treaties and conventions. When you sign some convention, sometimes under the convention there is some obligation you have to fulfill. Example. So there is a UN convention against corruption, not for corruption, against corruption. And this UN convention against corruption requires the member states, requires the signatories, people who have signed this, to create a body which will keep a check on the government employees. So the mandate is basically here to create ombudsman, and we have created one through a law called Lokpal and Lokayukt Act of 2013. Now, my point is, for those who don't know, you'll be studying this in your governance classes. Lokpal is a body comprising of maximum 9 people whose task is to look into and take care of and prevent any kind of corruption activity perpetrated by central government people, be it the central government employees, be it the MPs, be it the ministers, including Prime Minister, central level. Lokayukt is the similar kind of body at the state level, whose task is to keep a close watch, act as a watchdog on state staff, be it the state government employees, be it the chief minister, be it the state MLAs, MLCs, etc. But center has made a law for states also. How? Because center was a signatory to UN Convention Against Corruption. So if at any point of time, to fulfill, to give effect to meet the obligation of an international treaty, center has to make laws on stateless subjects, then the center is fully competent to make laws on stateless subjects. Are we clear, everybody? Kavanayan, in this case, guys, once the state has given up this power to the center to make laws, there is nothing in the constitution which mentions a procedure to take back this power. It's like this is a gift. If you give a gift to somebody, asking the person to give back the gift, uh, I don't think that is possible, right? Similarly, uh, the same concept here. The states can give up the power, but how to reclaim it? The constitution is silent on that. They have explained nothing on that, so we don't know whether it is actually possible to take back this power or not. Clear? That's it. Now, to improve the center-state relations, back in 1983, yes, once given, gone, gone forever, never ever to come back again. Now, back in 1983, a commission was set up to improve the center-state relations. That commission was called the Sarkaria Commission. I hope you all know this. Sarkaria Commission comprised of course, Ranjit Singh Sarkaria, Sivaraman, S.R. Sen, Rama Subramaniam, all these members. And this commission gave some recommendations to improve center-state relations. And Sarkaria Commission 1983 to 1988 gave over 247 recommendations. If you remember, we saw some of them under our topic governor, right? A couple of recommendations under the president's rule also. So Sarkaria Commission said, so basically what happens is when you have such commissions to improve center-state relations, the first thing the commissions do is to ask the states, what's your problem? Please share your concerns. Then only will I be able to look into the concerns and prepare a report and give some recommendation or advice. That is where the commission went wrong. It should never have asked the states, because the states then started making weird kind of demands. Some states like Punjab, Tamil Nadu, West Bengal, Kerala, they said that why do we have all these lists? There should not be any list only. There should be only one list, state list, and only 4 topics outside state list: defense, communication, foreign policy, and currency. Right? So, very strange was this situation where some states are saying that, imagine there should not be any list, only one list, state list. That was too much. Commission said, forget it. I think I made a mistake by asking you states. Then some other states said that, sir, there should not be any concurrent list. Merge the concurrent list with state list. Again, these were demands which could not be met largely, right? Now, when it comes to residuary parts with respect to taxation, the commission said that, see, when it comes to any topic of taxation, it should remain with center. But it's been 35 years now. If you find any new power which is not mentioned in any list, center, please modify the constitution and put them in the concurrent list. Let the states also enjoy powers to make laws on that. Why should you only have all the fun? Point one. Second point was that Sarkari Commission said that, see, we cannot cancel concurrent list. Please don't have these expectations that we can cancel concurrent list. But yes, center ideally do not interfere in concurrent list. Let the states make the laws. Let them enjoy. If at any point of time you feel the need to have nationwide uniformity, then you interfere. Otherwise, don't. Let it be. Let it be. Let the states make laws. For example, IPC, the Indian Penal Code, is actually a topic which is under criminal law, is a topic under, and the penal code is a topic under concurrent list. Now imagine this law is modified and say in a state of Tamil Nadu, to commit a crime, say murder, the punishment is 10 days of jail, and in UP it is death sentence. If the states amend the laws and amend the punishments differently, then don't you think all the people who want to kill somebody will drag them to Tamil Nadu and kill them there? That's possible. So certain things need nationwide uniformity. In those areas, center should make laws. Otherwise, on the concurrent list topic, let the states make the laws. Okay. Then one more thing. Article 200. Do you remember the concept of referential veto by any chance? I know it's been a long time. So, but some of you do. Great. So, referential veto. What is this referential veto? The governor will reserve the bill for the consideration of the president. So the Sarkari Commission said that governors, firstly, don't uselessly reserve bills. The bill should genuinely be such that it requires center's approval. Randomly, don't reserve every bill for the center. Don't do it. Secondly, center, when you get this bill, actually tell me something. When such bills are sent to center and the center sends back the bill to the states pass the bill again, is the president bound to give his assent? Tell me. Is it mandatory for the president to give assent? Of course not. Now, what was found was this fact that center, even though the bills would come to center showed no interest in returning the bill to states. In the first case only, they would keep the bill pending for 2, 4, 5, 10, 20 years sometimes. Now, come on. It is not as if you send back the bill and the state passes the bill again, you are bound to sign. Then what are you afraid of? I mean, every elected government has a right to know what's wrong in the bill. You are depriving them of this right. So, Sarkari Commission said at center, once you get this bill, dispose of in 4 months. Let the states know what your problems are. If the states don't incorporate your problems, then you can refuse to sign. But don't stop the bill in the first go only. So, such bills should be disposed of in 4 months. This was a Sarkaria Commission recommendation. Then, after a few years, in the year 2007, one more commission was set up. This was the Panchi Commission. Former Chief Justice of India, Madan Mohan Panchi. He was a Chief Justice in 1998-99 period. In fact, a very interesting backstory about him is that when Madan Mohan Panchi was supposed to become the Chief Justice, just before that, J.S. Verma was the Chief Justice. When Madan Mohan Panchi was a judge in Supreme Court, some lawyers wanted to raise a concern, raise a removal procedure against him. They were trying to convince the MPs in the Rajya Sabha to raise a notice for his removal. I think 20-25 MPs had already accepted that they will sign this notice. But then he became the CJI and the plan was dropped. Anyway, so Panchi Commission gave 312 recommendations. Now, some of the recommendations were outrightly rejected by the government. For example, Panchi Commission said that, see, in our country, we talk about federalism, right? Some states have no say in the national policies. Why? They are too small. Meaning, a state, northeastern state like Goa, Himachal, these are very small states in terms of their membership in the Rajya Sabha. So when you say that Rajya Sabha is a house which is a representation of states, do these states actually have any representation? I don't think so. These states don't have any representation because the problem is that it's too small to have any effect on passage of bills. Let's do one thing. Let's ensure equality. Let's ensure equality, just like US. Equal representation of states in the Rajya Sabha. This was already rejected by the government. That no, no, not possible. Why? Because in our country, some states are too small. Now imagine four or five states collectively come together and keep on preventing the passage of any bill. That would not be appropriate, right? So we cannot give this kind of power to the states. And we can very easily modify the states' boundaries and create more states. This also creates a problem of constantly modifying the number of MPs in the Rajya Sabha. So because of these reasons, it was said that no, no, that's not possible, right? Second was this fact that we till 2003 there was this concept that if you wanted to be an MP in Rajya Sabha, your name should have been there in the voter list of that parliamentary constituency, right? In that state. For example, that's not the case now. Like Nirmala Sitaraman, her name is in the voter list of Tamil Nadu, and she represents Karnataka in the Rajya Sabha. But till 2003, that was not the case. If you wanted to be an MP in the Rajya Sabha, you should have belonged to that same state. It was changed. Panchi Commission said, no, 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 that is not correct. In countries like USA, if you have to be a senator from any state, you should be from that state only. We should have the same provision in India. Why should a person whose name is in UP's voter list represent Karnataka? Why should somebody whose name is in Tripura voter list should represent Rajasthan? That should not be the case. But government said, no, no, no. We cannot follow all this. It's not possible. Rejected. Then the same topic where the Sarkaria Commission had said 4 months, the Panchi Commission said 6 months. Why 6 months? They gave the logic. The logic they gave was that Panchi Commission said that see, when the governor reserves the bill for the president and the president sends back the bill to the state government, the state legislature has to pass the bill again in how many months? Tell me. In how many months should the state legislature pass the bill again? 6 months. Otherwise, the bill is dropped, the bill becomes dead. Right? So, if the state is getting 6 months of time, center should also get 6 months of time only. And for the concurrent list, again, they said the same thing that, whenever center wants to make any law on the concurrent list, there should be a broad consensus before you actually jump on and make a law on the concurrent list. So the idea has always been the same, that on concurrent list, let the states make laws, let them enjoy. But if at any point of time the center feels that there is some problem with the laws, or there is non-uniformity in laws, then the center can intervene. Are we clear? Manaman Vijay Raghavan, sir, these are just commission's recommendations. The government may or may not accept recommendations. Are we clear? These commissions have given 200 and 300 recommendations. It is not possible to uh, add all these recommendations. Like sometimes the government rejects it outrightly, that no, not possible. Sometimes government says that we will look into it. In fact, for most recommendations, they say we will look into it. But sometimes some are rejected at no, not possible. But these, the government have said that, oh, we'll look into it, don't worry, we'll follow it. But they don't make any change in the law. Because if you change the law, then you have to follow it. So they say that, oh, don't worry, we'll try to do it. Okay. Just like you try to write answers. Always. Same thing. Government also says the same thing, that we'll try to do it. Right? Arey, sir, Abhishek, what are you saying, sir? 1/4 MP removal is only for the president. For the Supreme Court and High Court judges, 100 MPs in Lok Sabha, 15 Rajya Sabha. Sir, don't break my heart. Only few days are left for polity. What are you saying? Judges Inquiry Act 1968, sir, all mentioned. Don't forget all that. Okay. Then we have administrative relations. So, administrative relations are very simple. The idea is that on topics where states can make laws, the state's executive's power extends to those topics only. Sarkariya Commission gave recommendation to improve what? Madam to Madhuri, to improve center-state relations. That's what we are studying, right? So they gave recommendations to improve center-state relations. Gautami, government normally sets up these commissions to give them recommendations, comprising of experts who can delve deeper, get the state's opinion, and give recommendation to which may or may not be incorporated by the government. Now, administrative relation number 1. Article 256 says that executive power of state should not violate laws passed by parliament. Meaning, state government, your power should not infringe upon parliamentary laws. Of course, if parliament has made a law on some topic, state government, you follow state legislature only. Don't try to interfere with a parliamentary law. Are we clear? Very simple. Now, one more thing. Think of all these things like railways, means of communications like national highways, national waterways. All these means of communication of national importance, of military importance, they are spread all across the country. Like railway tracks are spread all across the country. Yes or no? Now, center cannot micromanage all these things. It's impossible. Center does not have any police force to keep a check on law and order at a ground level. So how will the center ensure that these means of communication are protected? How? Center cannot. It has to ask the states. So center can give binding direction to states, that states, come on, please ensure that the means of communication are protected in your state. In fact, center can also tell the states, come on, construct something. So this is the binding direction given by the center. Now you may say, sir, but if the center is asking the state government to protect the railways, the state has to spend some money in protecting the railways, right? Who pays the money? So don't worry, center pays the money. So for this, an amount is paid by the center to the state. Now, if the state says, or the center tells the state, center is saying the states, to the states now. That state, come here, Maharashtra government or West Bengal government, ensure that you maintain all the railway tracks in your state. Take 25 rupees. Go, perform the task. What kind of amount is this? Nonsense. So if the state finds amount to be insufficient, if amount is insufficient, then state can approach the Supreme Court. That Supreme Court, see what the center is doing. It is asking me to perform all these things and giving me a 5-star only. Sorry. So here, Supreme Court will appoint a person called arbitrator. This arbitrator's task, this arbitrator's task is to fix an amount. Fix an amount, and this amount will be final. Will not be challenged anywhere. Are we clear? Do we understand all this now? Okay. So this is the administrative instruction given by the center to the states. There are 3 more areas where the instruction is given. The center can give binding orders. These 3 articles very important but very easy. Very simple. First one, the center can tell the state that state, please come up with schemes and programs for the welfare of the scheduled tribes in your states. Article 339 clause 2 says that the central government can give binding direction to the state to create schemes and programs which are very important for the welfare of scheduled tribes. Clear? Simple. Then this article 347. Now, when it comes to any state, now think of this. Lakshmi arbitrator can be either, but nothing is mentioned who the arbitrator has to be. So ideally, some retired judge may be the arbitrator, because that's what Supreme Court knows. They only know retired judges, but nothing is mentioned on what is the qualification of an arbitrator. Now, every state has its own official language. I hope you're aware. Some states have Hindi as the official language. Some state has Tamil. Some has Kannada. Some has Odia, etc. Right? Every state has its own official language. But if in your state, a substantial group of people start speaking or speaks a different language, let's say in some state, there are some people who are die-hard fans of South Korean rom-com, cringe-worthy rom-com movies, right? And they day in, day out watch series after series of these rom-coms, the South Korean rom-coms. So much so that now they have started speaking South Korean only. They don't understand anything. What is Tamil? What is Hindi? What is Telugu? I don't know. South Korean language, right? Now, they may approach the president and tell the president, please ask the state government to also give or make South Korean as an official language in the state for administrative purposes. Are we clear? Now, let's read. On a demand being made in that behalf, the president may, if he is satisfied that a substantial proportion of people, not 20 people have gone, no, 5 lakh people, 10 lakh people, desire the use of any language spoken by them to be also recognized by that state, then the president can direct that such language shall also be officially recognized throughout the state or in a particular part. Clear? So this is with respect to the Article 347. I hope you'll remember this. And one more Article 350 capital A. It simply says that if at any point of time, so yeah, sir, we don't, this is the article, sir, and we don't know what is the percentage. Substantial proportion, 5%, 2%, 1%, that we don't know, right? Because it can keep on varying. 5% of Sikkim is no match to 5% of Bihar in terms of population, or 5% of UP. So percentage may not be a good idea, right? So it depends. Nothing is clarified there. Now, Article 350 capital A says, and I think all of you would agree here, that if kids are taught in their mother tongue, at least in the early or primary stage of education, the learning outcomes are faster. Would you agree on this? That if a kid is taught in their mother tongue, the learning outcome is slightly better. And beyond this, if you are a linguistic minority group, meaning you speak a different language than the other people in the state, you also need to protect your language, your culture, your custom, right? So when it comes to the culture and custom being protected, Article 350A says that every state should, and every local authority also should strive, take the effort to ensure that the linguistic minority groups in the state, people, a small group of people who speak a different language than the majority people, the kids of these people, right, this group, they should be imparted education at the primary stage only in the mother tongue. Are we clear? In the mother tongue. And in this regard, if the state is not doing anything, the center can issue directions also that state, please incorporate. Please do it immediately. Okay, that's it. Are we clear so far? Neha, sir, we have two official languages, Hindi and English. We'll discuss that later on. We have two official languages for the central government, not for states, right? There are some states where it would be uh, more than 2, 4, 5 official languages. Should I need to mug up these articles of 350A? These articles of 350A, this is only one article. And what is there to mug up? Have I ever told you to mug up articles? I tell you at least know the crux of the article. I don't think it's difficult. Maybe it's early morning and some of you are not morning people clearly. So that could be a problem. But it's very simple that we want the linguistic minority groups to impart their kids to have their primary education in the mother tongue. Simple. And the state should take the effort for this. And if it is not being done, then the center can give binding directions. Okay. Dhanya Abhishek, I will discuss languages later on. Don't worry. Not right now. Haji Sandeep, what is your concern? Tell me. Do they need to give written requests? So what kind of request will they give, Sandeep? Tell me. On WhatsApp. At least raise a viable concern for me to respond to your concern. The request needs to be in a proper format, right? We are talking about a resolution being passed by the states. We can't give a WhatsApp forward to the center that make laws for us, right? What else is the doubt? Tell me. Joy Paul, when such demands are made, does center check its real ground or just fund the states randomly? In respect of 339, though there is no funding involved in 339. I think you are getting confused here. There is no funding involved here. You have to make schemes. Simple. And for how much time will the law operate? Forever. The law will continue forever. Deepshika, the percentage is very, very low. Yes, Ananya. Ombudsman means watchman. Or a watchdog, rather. Okay. Done. All okay now? No concern so far? Yes, Meshak. It is possible to have 4 or 5 official languages. Pihu will discuss that later on. Don't quote fundamental rights right now because the knowledge of rights that you may have is very limited. Once we have information, then we can make informed statements. No, Mayank Vadvani. States have no power to make any change in the law. Clear? Okay. Now, issues in administrative relationship, it's very simple. We know very well what kind of issues are there. Issue number 1, the abuse of Article 356. Please tell me what is Article 356. Any idea? President's rule. Article 356. Though it has come down since 1990s. Since 1990s. Why since 1990s? Tell me. Why has the misuse or abuse of Article 356 come down since 1990s? Any specific reason? Yes, of course, the specific reason is the SR Bommai judgment. Because of that, the misuse has come down drastically. Okay. Second is the role of governors. I think we have no dearth of examples here. States like West Bengal, states like Kerala, etc. I would not say Tamil Nadu because I don't find the governor of Tamil Nadu particularly being against the state government. A well-traveled, extremely educated person is a governor. So I don't see his actions to be completely out of sync. Maybe a couple of issues here and there, but not a very serious concern, right? Sometimes it's also uh, the state governments, right? Tamil Sai Sundarajan, I don't feel that she is particularly very insistent on doing things. She has been ill-treated also by a Telangana government. They did not allow her to give a governor's address, right? So let's also understand that you need to show respect to the governor's position, right? But anyway, these issues and friction will always happen, and it depends on uh, largely what information you are able to understand and how biased you are. Because the governor is an outsider, so a local person may always view them as some external central agent. And also, it largely depends on how your state government is trying to present this in front of you, right? Then the center state conflict with respect to AIS. What is AIS? All India Services, AIS management. So again, I think we discussed yesterday only how the states are so angry and upset that we have to pay them. No, we have to maintain them, pay them money. Everything is being done by us for them, right? And you have given them to us, but we can't control them. These people always owe their allegiance to the center, etc. So that's a concern. Now, finally, how to coordinate between the center and states, how to improve the relationship. So there was a provision in the constitution, article 263, which said that the president can create an interstate council, and in 1990, based on Sarkaria Commission recommendation, we set up an interstate council. What was the purpose of this council? The purpose of this council was to improve the relationship between center and states, to provide for enhanced coordination between center and the states. And this particular council comprised of the prime minister, the CMs of all the states, 6 union ministers, and administrators of all the UTs. It was a very big body. This body was originally slated to meet twice every year to resolve problems amongst the states and between center and states. But this body has met only 11 times since 1990. Last in 2016. And before that, 2006. So in the last 17 years, this body has met only once. So it's largely defunct. Defunct means non-functional. The body is still there. It has not been cancelled, not been dismissed, right? Not been repealed. But it's non-functional. It is non-existent. No meeting takes place. And this body has some inherent problems also. Point number 1, to tell you from your own life and personal example, please tell me, every year, hundreds of people clear the examination of UPSC. Hundreds of people. 700-800 people. Do you have any problem? No. It's okay. But if your neighbor clears UPSC, if your relatives clear UPSC, then your life becomes hell in the house. Yes or no? Right? We are more impacted by our neighbors, by our people, by people surrounding us. That's a real problem, right? So what problem will uh, say a state like Meghalaya have with Kerala? Or why would Tamil Nadu be concerned with Haryana? Or why would Jharkhand have any problem with, say, Andhra Pradesh? No concern. You are largely impacted by, or you have problem with your neighbors. This body collectively comprised of all the states. So made no sense. Secondly, this body was based on equality. Every state was given equal time to raise their concerns. So once in a meeting, the Sikkim CM spoke on the various concerns that he had in the state, and then he was asked, time is over, and then Tamil Nadu CM also spoke, and she also raised concerns over various elements in the state which were a problem. And she was cut abruptly in between and saying that, see, we give equal time to all the states. She became very angry. She said that I command a bigger state. I have more problems. You cannot equate a larger state's problem with a smaller state's problem. And she walked out of the meeting only. Nonsense. So this is also a concern. So this body has not been very effective. Also, we already have these meetings are held in Delhi or any place as the governments may think fit, right? So there is no such location, there is no official building, interstate council building. They can be held anywhere. Now, one more reason for the failure of this body was that we already have certain bodies in the country to promote coordination. We call them zonal councils. These are statutory bodies. So back in 1956, through the Seventh Amendment Act and the States Reorganization Act, zonal councils were formed. What was the zonal council? So what we have done is we have collected the neighboring states and put them in a club. We call it Northern Zonal Council, Central Zonal Council, Eastern Zonal Council, Western Zonal Council, Southern Zonal Council. ZC stands for Zonal Council. Okay. So look at this now. Say an Eastern Zonal Council. Look at the members. Neighbors are members. What's the purpose? What's the function? The function is to prevent the development of acute center state consciousness. We should not have intense center state consciousness. Yashi, sir, please write important points on slides. Am I not writing important points on slides, Yashi? What important points to write? That Jayalalitha walked out of the meeting in a ISC meeting in 1990s. I don't think that's an important point to write. Is this your first class? Strange. You make strange kind of remarks in the class. Disheartening, demotivating. Hey, what is the concern that what has not been written on the slides? I am constantly delivering a lecture. Don't expect me to write everything on the slide. I write whatever points are relevant for the examination. You are free to write your running notes. You want me to write a book here in the class? At least have a basic understanding of being reasonable and logical. The more spoon feeding is given to you, the more casual you guys become. And then you expect to clear the examination and man a district and run the nation. God save this country if this is the quality of people you'll get in the administration in future. Anyway, so preventing the development of acute center state consciousness. See, when it comes to acute, intense center state consciousness, that, oh, this is my state, central problem, I don't care, my state's problems are the priority. If this is your issue and this is the concern, then there is a serious problem with country's growth and development, right? See, it's very good that you are a believer in son of soil theory and all, but frankly, we should not ever focus on our state's development at the cost of nation building and all. So this was the idea, that we should not develop an acute, intense sense of center versus state. I don't care, central problem. By UP is suffering, that's their problem. I am from Maharashtra, I don't care. Farmers are committing suicide in Maharashtra, that's not my problem. People in Tripura are safe, that's it. This should not be the case. And also, to develop the habit of cooperative working. Cooperate and make recommendations on center state and state state disputes. If there's any dispute happening, then they can sit together and resolve those disputes peacefully. These are the functions. Look at the membership now. Every zonal council is headed by the Home Minister. HM stands for Home Minister. Mr. Amit Shah, as of now, don't think that he's a permanent member. Every zonal council is headed by the same person. Are we clear? Amit Shah is the head of this zonal council, this zonal council, this zonal council, this zonal council, this zonal council. Every zonal council. Okay. Now, the CMs of all the states, member states, are also members. And two other ministers from the state who are chosen by the CM, they also sit in the meetings. Apart from this, if the zonal council has UTs, then the administrators of UTs are also a part of the zonal council. Beyond that, the chairman is the home minister, who is the vice chairman. CM by rotation, meaning, let's say this year, in the Eastern Zonal Council, Bihar CM is the chairperson, a vice chairperson. Next year, Jharkhand CM becomes a vice chairperson. Next year, Odisha CM becomes a vice chairperson. Next year, West Bengal CM becomes a vice chairperson. Next year, again Bihar CM. So by rotation. Pooja, Telangana, basically Andhra Pradesh has been bifurcated now. So Telangana is in the Southern Zonal Council only. Okay. Now, one point that you may raise is, sir, you are referring to all the states. Where are the northeastern states? Where are they? Don't worry. In 1971, we created a separate council called NEC. Through the NEC Act, this NEC was created. This comprises of the 7 sister states and Sikkim. Okay, so Northeastern Council is a separate council created under a separate law, which is the NEC Act of 1971. And here, governors are also members of the council, unlike in the other zonal councils where governors are not members. Clear? The governors are members in these councils because in all these states, governors have special powers, either through Schedule 6 areas or through Article 371A for Nagaland, etc. That is why, apart from the CMs, governors also are members here. Clear? And in the Northeastern Council, who is the chairperson? Chairperson will be nominated by the president, but please, the chairperson is the home minister only. It's a convention, it's a custom that the home minister is the chairperson. Clear? One small point. No, Asif, that's not the case. Nobody comes there. Center is already sitting. In these zonal councils, you also have advisors. Who are these advisors? So, in your state, what is the highest post of an IS officer? Any idea? At the central level, it's the cabinet secretary. But in your state, what is the highest post of an IS? We call them chief secretary. So here, chief secretaries of member states, they are also a part of these meetings, playing the role of advisors. Clear? So once you become the senior most IS officer in your state, you will become the chief secretary and you can sit in these zonal council meetings. For that, study hard, write the answers properly, and then in future, possibility of that will be there. Now coming to financial relations, before we discuss the financial problems, one question that we need to address is, what are the limitations on the state's power to collect taxes? Limitation number 1, states cannot impose tax on import export. Yes or no? Import export. Who will impose the tax? Center. States cannot levy tax on interstate trade. Without center's permission, you cannot impose tax on interstate trade, because we have borrowed this concept from Australia that there is freedom of trade and commerce in the country. Okay, one interesting point. What is this article? Any idea? Which topic did we cover this Article 276 in? Tell me. Which topic? No idea. Municipalities. Suggestions. So basically, there is a concept called professional tax, where the upper limit of professional tax right now is how much? Rupees 2,500 per year. Rupees 2,500 per year. And who decides this? Center decides this. Last time it was decided in 1988, and that is why the second ARC said increase this limit. And if you remember, the 14th Finance Commission had said that increase this to at least 12,000 per year. But this money collected by the state given to municipality, the limitation is that you cannot collect more than 2,500 rupees, which is a limitation imposed by center. Then, do you remember this immunity of instrumentality? Yesterday only, two articles, 285, 289. Center and states can't tax each other. So one more limitation on the state is that you cannot tax state central government buildings. You have to provide all the services, drainage services, sanitation, hygiene, water, etc., but can't tax them. And one more thing, think of the same income tax office. Does the income tax office require electricity? Tell me, yes or no? How will the computers run? How will the people charge their phone there? Because while playing Candy Crush, the phone gets discharged also. So how to do that? So you need electricity. Now, Article 287 says that whatever electricity these buildings consume, right, center or the state, sorry, cannot impose tax on that. No taxation on consumption of electricity by state government on central buildings. Now, I think I need to clarify one point here. Please don't be confused. When it comes to the money being paid on consuming electricity, there are two components of it. If you ever see your electricity bill, it has two elements. One is the basic tariff, the number of units you consume into price per unit. That's a basic money you are paying to consume electricity. On top of it, a tax is imposed. So basic tariff has to be paid. The state government will not impose tax on that. Are we clear? So that will not be done. Okay. Now see, Anushka and Soyab, why have we not included this here? Because there are other situations where the central government may consume electricity, but may not be necessarily used in a government building. It could be used for other purposes also. For example, if the center asks the state to provide some kind of power or electricity to a neighboring state for certain periods of time. So center takes this, and center gives you money for that. You can't tax the center. That, so it has a wider connotation on use of electricity. Are we clear? uh, Lakshmi, this CM means chairman. I never thought that this could also be a concern. And this CM means chief minister. Are we clear now? Somebody had a problem here. I hope there is no concern. This CM means that vice chairman, and this is chief minister. Two different things. Who has a say in case of any dispute? See, it is done through consensus. And if there is any dispute, there is a central home minister who will decide on things. But there is no order that comes here. If, let's say, Karnataka and Tamil Nadu are fighting, let's assume, and the matter has gone to a zonal council. Now, the home minister will try to convince them that don't fight, guys, let's find a middle ground. Let's say Karnataka agrees or Tamil Nadu agrees, but the other state is not agreeing. No, 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 I don't like this. Then go to the court. Because the only place which can give a binding order is the court. Zonal councils are not places to give binding orders and all. They are places for mediation, peaceful compromise. So both parties have to agree on that. If you are not in agreement, please go to the court. No, we don't need to mug up all these states' names, not required. So this is a limitation. Lastly, one small body, Finance Commission. This body, Finance Commission, is a constitutional body. Article 280, and the Constitution says that what is the qualification of members of Finance Commission? The qualification will be to be decided by Parliament by law. And Parliament has passed a law. And what is that law called? That law is called the Finance Commission Act of 1951, based on which the chairperson should have knowledge of public affairs, and other four members should have knowledge of finance, knowledge of economics. One should be a retired sitting or person qualified to be a high court judge, and somebody who has experience in financial matters and administration. This is a 5-member body. Please tell me, what is the qualification to be a high court judge? Difficult time. Revision time is always a difficult time. Tell me, what is the qualification to be a high court judge? Please write all the qualifications in one statement only. Krishika, Ananya, Kavana, P. Chandranath. Only people with absolutely correct answer. Dudekula. Okay. Others, point number 1, 10 years practice as judicial officer. Okay, meaning in the lower court, or 10 years advocate in the high court. Please type yes or no. Okay. An eminent jurist is also a qualification to be a high court judge. A for yes, B for no. Eminent jurist. Not for high courts. A lot of you have marked yes. Eminent juris is only for the Supreme Court, guys, not for High Court. High Court only two qualifications: 10-year judge, 10-year advocate. Don't write 5-year judge. 10 years. Okay. What's the function of Finance Commission? Very simple. Finance Commission's duty is to make recommendations to the center on what? On how much money will be given to the states, what will be the distribution between the union and the state. So center and the states, what will be the distribution, what percentage of funds or what percentage of taxes collected will be sent to states and what percentage will be kept with the center. Vertical devolution. The distribution between the union and the states. This is what is called vertical devolution. And now, if let's say I have decided that center, you keep 60%, states, you keep 40%. But then states are of different sizes, different population, different growths, different forest area, etc. What percentage will UP get? What percentage will Bihar get? What percentage will Telangana get? What percentage will Maharashtra get? That is also recommended by the same Finance Commission. So this refers to horizontal allocation. Amongst the states, how is the money being distributed? Okay. Beyond that, what will be the principle which should govern the grants in aid? Grants in aid means what? How much money can be given by the center to the states without any conditions attached? Free money. Go take this money, enjoy. Waste it on subsidies. I mean, invest it in building infrastructure, whatever. Right? So, what money can be given? That is also recommended by the Finance Commission. Beyond this, the Finance Commission also advises the state governments what steps you need to take to augment. What is augment? Augment means to increase. To increase your CFS. Why? Because if you increase your CFS, then there'll be more money which you can send to panchayats. If you increase your CFS, there'll be more money to be sent to municipalities. So the Finance Commission also makes recommendations to the state governments on what steps you can take so that your CFS has more money, which can eventually be used for what? For enhancing the resources which can be devolved to the panchayats and municipalities, because we know very well the big problem for panchayats and municipalities is 3 F's. Yes or no? What is 3 F's? Funds, functions, and functionaries. So that's also there. Now, last topic, issues in the financial relations. What are the issues in the center state financial relations? Point number one, the first problem that states have is the borrowing problem. See, let me tell you something. Article 292 says that center can borrow from outside. 293 says that states need the permission of parliament to borrow money. Center can borrow from within or outside the country. Are we clear? But states need the permission of parliament to borrow. So whatever money is sent to the states is actually sent via the center. Now there are two problems. Let me explain that. Let us take an example here. Let's say IMF is giving to some state government, say $500 million for some project. Normally these loans are given at very soft interest rate. What is a soft interest rate? Soft interest rates are low interest rates. Let's say 3%. This money is actually given to center because center will act as a guarantor. So this money comes to the center and center will then send this money to the concerned state, acting as a mediator, intermediate, as a broker, as some kind of agent. So what happens is the states say that when the IMF or ADB or whatever, World Bank, IBRD, they are giving us money, they are charging 3% interest, but central will give the money to state and central will say, you please pay 3.03%. Some 0.02% extra, 0.04% extra. Why? Some commission. They are saying that we have to charge this money because we have to maintain the records and accounts, and administrative expenditure is there. And state governments say, what kind of nonsense is this? You are sending money to us, which we'll use for the betterment of the people of this country only. It makes no sense that one level of government charges interest from other level of government. Right? So this is a problem that states have. That center acts like a commission agent. They're trying to make money from states only. Right? Maybe some crores of rupees can come as commission, and they will say, we have to maintain the records and all. We have to for administrative expenditure, because we have to hire somebody or we have to allocate the task, purchase one computer and then enter the data, when the money came, when the money was sent. We have to maintain records. For that, some money is spent. That's problem number one. That center charging additional interest. Second thing, states also say that this money has come to us, but center will never give this fund at one go. What will center do? This $500 million in installment. $20 million now. Then the state says, sir, now please give money, some more money, take 20 million more. Sir, please give more money, take 20 million more. Now center says that we have to keep a track of whether the states are misusing money. States say two things. Number one, what track? What keeping a track of this expenditure? You already have a CAG who will give annual report on where the money is being spent. Then what's the problem? Number one. Number two, states say that you always devolve money before elections and then use that as a gimmick. That see, we are spending so much money in the state, we are sending crores of rupees in the state. So money being sent in installments and not at one go, constantly keeps the state with a begging bowl in front of center perpetually, even though the state is under the obligation to pay all the taxes, all the interests, but still the center acts like a boss. Problem number one. Second problem, excessive control over the fiscal resources. Center collects all the important taxes, income tax, corporate tax, etc. These are the most important taxes in terms of revenue generation. Center controls it. Now, states say why? Center says two reasons. What is the reason for excessive control? Reason number one is defense. Center says we have to defend the country, right? Center says that we have to ensure the defense. Number two, center also says that we need to ensure balanced regional development. Now, states are very upset at this. States say that what is this balance that you're talking about? If states like Gujarat, Maharashtra, Tamil Nadu, Karnataka, these handful of states comprise 50% of industrial production in the country, where is the balance? Let me ask you a question. Do you think that we have a balanced regional development in the country? Tell me. In the previous few years, how many new projects have you seen coming up in a state like Bihar? How many new industries are being set up, say in West Bengal or in Madhya Pradesh or in, say, Chhattisgarh, compared to, say, a state like Telangana or a state like Tamil Nadu, state like Maharashtra, Gujarat? Where is the balance? There is no balance. It is mere lip service. We have pockets of underdevelopment in this country. And sadly, the states which have not seen development are constantly lagging behind. And the gap is ever widening. It is very difficult to, fill this gap now, right? And the more you don't take care of the states lagging behind, there'll be a bigger divide in terms of industrial growth. And then you say that we want to ensure balance in the country. So this is an utter nonsense. So states don't agree with this concept. That is why the excessive central dominance which the states claim, the reason for this is these two. This is not visible in the country. This is the allegation made by the states, that you are saying that this is a reason, but this is something that is not possible, right? Now, point number three, pay commission. Girish, but the interest is of particular period is on only the released amount. How does that matter, Girish? On the released amount, the interest is charged, not on the total amount. Okay. Sandeep, from which fund salary of AIS officers are charged? Don't use the word charge, Sandeep, please. Charge expenditure is a fixed word used only for certain categories of people. We have seen that under the charge expenditure concept under budget, right? And also under the topic precedent. The corresponding state government pays a salary for the IAS IPS officer, or the center if you are placed under center. Interstate Council is not a constitutional body, but it is created under the provisions of the Constitution. Vice chairman in zonal council is a chief minister. What else do we have as a doubt? 3Fs and all, it is mentioned in your panchayat classes, refer to 3Fs, funds, functions, functionaries, right? IMF, yes, the International Monetary Fund. Right? Take IMF, World Bank, anything. It's just an example. Sibam, sir, maybe reason pandemic. What pandemic? Pandemic is not a reason. Control has been since independence, right? Pandemic happened just 2 years back. Now, pay commission awards. What's the meaning of pay commission awards? Every 10 years, there is a revision in the base salary of the central government employees. Not the annual increment. That happens naturally. The base gets revised. Okay? That is called the pay commission award. Now, what is the problem that states have? Understand the state's logic, which is very genuine. Think of this. There are two buildings. Let's assume these two buildings. This building is an excise department building. And this building is the income tax building. Both buildings are, say, side by side. In this income tax building, there's a clerical staff, Group C employee. In this excise department building also, there is a clerk, a Group C employee. Okay. Now, central government, it will pass its pay commission award, 7th pay commission, and it will increase the salary of its clerk, say to 35,000 rupees now. Now, in the next building, the clerk, who is a government of state government employee, he is still getting 24,000 rupees. I'm just giving an example. Right? Just 24,000. Now, will he not pressurize the state government that give me more money? I am doing the same kind of work practically, but why are they getting more money? So they will talk to their union, strike, hartal, dharna, agitation, give more money, right? And the state government is forced into increasing the salary of the employee. State government say, by center, you have all the resources. You can increase the salary, you can borrow from outside and give more money. We can't. We have limitations. We don't control revenue resources. You control the major revenue resources. So states say, states want, number one, to be consulted vis-a-vis or with respect to salary revision. And number two, states want additional resources, meaning money, for salary revision of their employees. Because the state government say that if the center has increased the salary of their employees, we will have to. We simply cannot ignore it. It is not possible only. The state government will force us, the state government employees will force us into increasing the salary. So we cannot ignore this. Simple. Did you understand this point? Everybody? Is it clear? Okay. Lastly, I'll ask you a simple question here. Please tell me, what topics do you think are revenue generating topics? What is an area which gives money to the government, any government? give me a broad area. Through taxes, but taxing what? What do you tax? Okay, somebody is saying trade and commerce. Agreed. You can tax trade and commerce. Okay. Taxing goods. Goods are made through what? Industries. Okay. Taxing industries. So we can simply say that industries, a very good source of revenue. Trade and commerce, a good source of revenue. Mines and minerals, yes or no? A very good source of revenue. All the examples you are giving, can we put them under these categories? Yes or no? The major revenue sources, major ones. You will be surprised to know that all these topics are in state list. All these topics are a part of state list subjects. Industries, entry number 24. Trade and commerce, entry number 26. Mines and minerals, entry number 23. These are all entries in state list. Meaning, all the lucrative topics, most lucrative subjects of state list, they're in the state list. But still, the center controls them. How? Because of a small problem. And the problem is that each of these topics have a corresponding union list entry. Industries. If you look at industries, it's also mentioned in the union list. Entry number 7, entry number 52. If you look at mines and minerals, it's also in the union list. Entry 53, entry 54, entry 55. Or trade and commerce, concurrent list, entry 33. And what it mentions here is that the parliament can make laws to control industries if it is urgent in national interest. Now tell me, if you make this kind of statement that if it is very urgent in national interest, then the parliament has the power to regulate industries. Don't you think the parliament will say, yes, it is very, very urgent in national interest? Then everything is urgent in national interest only. What is national interest? It is not defined anywhere. The problem with these words is that you can't define national interest. It is very subjective. And we have seen that the central government practically controls everything, right since 1950s. In your economics class, you'll be studying about these policies like IDRA, IPA, etc., where the center has practically monopolized all these topics, excluding the state governments from any kind of control, right? So when you have this kind of statement, it actually leaves lot of room open for the states. So when you say that in public interest, center can regulate, then center will always regulate it. Always regulate it. That is why the last point, now you read the last point, it will make more sense to you. Most lucrative topics, right, of the state list have been practically monopolized by the center in the garb of this right, center, state, in the garb of these union list topics, right? That's it. Okay, but Rajan, the control is always with the center. The ultimate decision making authority is the center, despite the fact that the state should have been the decision making authority. That's our concern. These are issues in the financial relations. We are done with the But since 1991, it need not pass. All the old laws favor the center, and center controls everything. So why do you need to pass new laws to harass the states further? Not required, right? Look at even the GST devolution. Is the GST devolution being done on time? Tell me. Are you following the newspaper? Don't you read all these things that states are constantly crying, "Wait, give our GST share, give our GST share," right? When has it ever happened that the states are always doing all these things regularly? Not. In most center is doing these things regularly. In most cases, not. So eventually, these are genuine concerns that the states have. That brings us to an end of our discussion on the topic center-state relations. Easy questions being asked. Things like, how far do you think cooperation, competition, confrontation have shaped the nature of federation in India? Give some recent examples. What is confrontation? We saw yesterday cooperative features, cooperative federalism, competitive federalism. What is confrontational federalism? Tell me. What do you write here? What kind of features cause confrontation? Don't give me meaning of confrontation. Okay, yes, somebody wrote this. Unitary features, right? Please give examples of unitary features which cause confrontation, cooperation. You can give examples of in the pandemic also how the center and states cooperated. The All India services, competition, various lists are being released, good governance index, e-governance index, etc. Confrontation, again, governor's role, misuse of president's rule, control over resources, right? Improper allocation of GST, then issues that we have seen here, confrontation. Are you clear? So you can watch. I hope you're all aware that all these PYQs, the recordings are available. Please take some time out to watch the answer discussion in the tablet, right? And it is perfectly all right to watch the recording first and then solve the question. Competition example, Pallavi. Various indexes. Then the states also compete for devolution of funds. Then international projects. Why would any company come to Bangalore to invest money or go to Tamil Nadu or Gujarat to invest money? Why not Bihar? Why? Because the state governments of Tamil Nadu, Gujarat, Maharashtra, Karnataka, they have provided ample opportunities and avenues for setting up of these industries, which certain state governments have not provided. Competition, right? I did not know about it. Guys, for those who don't know, there is actually all the recordings, not just of polity, all the topics. You have the answers discussed available of PYQs, prelims and mains, right? So please watch them. Important articles: 249, 250, 252, 253. Then 263 Interstate Council, then 339, 347, 350 capital A, 280. No schedule, No important case to be known here. In case you want to read Lakshmikant, please follow chapters 13, 14, 15. 13, 14, 15. Done. Skilled labor force is the main reason. Sir, in most of these states, it's not the locals who are only working. Most of the people are outsiders who are working, right? It's never skilled labor force. Skilled labor force will move to areas where there are job opportunities. Don't you find people from northern states working in huge number in these southern states? Tell me, yes or no? That is never all a very genuine concern. Okay. Now let's begin our discussion on fundamental rights, but let's take a quick break. We'll come back. Available topics so that's the lawmaking power, but 256 is the executive power. Sir, you're on mute. No, I'm not on mute yet. It's okay. Yes, that's true, but to protect the railways, some money has to be sent, right? And that money is separately dealt with under the provisions of Article 257. Okay, let's begin now our discussion on fundamental rights, part 3 of the Indian Constitution, Articles 12 to 35. I will not be telling you which articles are important here. Are we clear? And why will I not tell you which articles are important? Tell me. Because every article is important, right from Article 12 to Article 35. But before we discuss, I need to know your opinion on rights in general. What do you think? Please mark the answer for this question. I'll give you a minute, think properly, and then mark the answer. Rights are privileges of few against many. Nonsense. Now, rights are privileges or rights are claims? Rights are claims. They are entitlements. They are not some benefit or privilege given by the state. A benevolent state in a feel good mood gives you some benefits. No. These are some things that we have as entitlement. Don't ever think of right as your privilege. It is your claim. It is your entitlement. You need all these things. You deserve all these things. Clear? So rights are never privileges. And secondly, not all rights can be incorporated in the constitution. Right? Few rights may not be mentioned in the constitution. So that may also be there. Now, before we discuss rights, firstly, I need to clarify the categorization of rights. Categorization of rights. There are various laws in the country which provide for various types of rights. If you take an example of a law, say RPA, 1951. RPA 1951 does it not give us the right to vote? Yes or no? Or a law called Industrial Disputes Act. This law gives us the right to strike. And then you also have the Constitution of India. Is the Constitution of India a law? Yes or no? Tell me. Is the Constitution a law? Yes, of course it's a law. Is it not a law? Some of you are writing no. Is the Constitution not a law? It's the most important law in the country, the fundamental law in the country, the supreme law of the country. Now, when you get all these rights through some laws which are protected by laws, we call these rights, we call all these rights as legal or statutory rights because they are given by a law. But if any right is given to us by the Constitution, can we also not call that right a constitutional right? For example, take the case of, say, Article 300 capital A. This gives you the right to property. Now, if there is any right which is mentioned in the Constitution, can I call it a constitutional right? Yes or no? Now, you can also call it a legal right or a statutory right, but a more appropriate word would be calling it a constitutional right. Now, inside the Constitution, there is a specific part which is called Part 3. This Part 3 gives us various kinds of rights. For example, the right to life. Now, all the rights mentioned here in this part, they are referred to as fundamental rights. Can we call these rights as constitutional right? Tell me. Yes or no? Yes, we can. They are all in the Constitution only. Can we call these rights as legal rights? Yes, of course. They are given by this law called Constitution. We can also call them legal or constitutional rights, but a more appropriate word is a fundamental right. Can we call ourselves inhabitants of the earth? Yes or no? Can we call ourselves inhabitants of the continent Asia? Yes. We can also call ourselves inhabitants of the country India. All three things are correct, but a more accurate thing would be that we are Indians. Same thing here. So it is just like this diagram. These are constitutional rights. These are fundamental rights. And ultimately, they are all a part of legal rights. Legal right, constitutional right, fundamental right. I hope we have understood this entire classification. There is no concern whatsoever regarding this. Should we move on then? Great. Let's move on. First question would be, why are we calling these rights fundamental? Now you'll say, sir, because they are very, very important. They are very essential for the all-round development of an individual, right? All-round development. They are essential for the overall growth. They are essential for the social development. They are essential for the moral development. They are essential for the ethical development. They are essential for the educational development, overall development. But let me tell you, this is not the very accurate reason why we call them fundamental. We call these rights mentioned in part 3 as fundamental rights because they have been guaranteed and they are being protected by the Constitution. And we call the Constitution as the fundamental law of the land. So why are we calling this Constitution the most fundamental law? Why? A fundamental law is the most basic law, the original law. But there are so many laws which are older than the Constitution but still exist. Yes or no? IPC, CRPC, the old one, CPC, Indian Evidence Act, Indian Police Act, Negotiable Instruments Act. Dozens of laws exist. Still, we are insisting that no. Constitution is the most fundamental law. Why? Please always remember, there is an article on this which says that why we call this rule book as the most fundamental rule book is because all laws in the country can only exist because the Constitution allows them to exist. All laws derive their authority, the power, from the Constitution. Derive authority or power from Constitution. Are we clear, everybody? This is why we call these laws as the fundamental, these rights as the fundamental rights because they have been protected by the fundamental law of the land, which is called the Constitution. Clear? Okay. Lakshmi, all FR are CR and LR, all CR are LR, but all LR are not FR and CR. All FR are not CR. No. All FR are CR. You have mentioned same thing, Lakshmi, and given the opposite again. Last statement is not correct. Rest are correct. Clear? Let's now begin our discussion on fundamental rights. But two things need to be known. When we say that rights are protected by the Constitution against the state, state will not take away your rights. The point is we should know exactly what is a state firstly. So for the sake of only part 3, Don't use this definition in other places. For the sake of part 3, state means this. Yes, Lakshmi, correct. State means this. The parliament, the assembly, of course, the council also, the very useful bodies called the legislative councils, they are all a part of state. The government of India, government of state, part of state. All the local bodies, panchayats, municipalities, part of state. And the constitution says other authorities. What the hell is this other authorities? Such a vague kind of word. Let me ask you a question. Is Byjus a part of state? Tell me. Is Byjus a part of state? Or you are saying no? Is SBI a part of state? State Bank of India? You are saying yes. Strange. Is police a part of state? Police. Okay. Is a guard in front of an ATM, is he a part of state? No. Okay. So somehow you are making this assumption based on certain facts. What are those facts? So the idea is that you feel if the state, if the government controls the body, it is a part of state. That is what your assumption, right? But the point is, how do you determine whether government controls the body or not? This matter actually came up for discussion in 1981 because of a problem in Jammu and Kashmir. So this case is called Ajay Hasia case, where Supreme Court has clarified what is the meaning of Article 12, other authorities. So what is the case story? The case story was that we had this REC Srinagar. What is REC? Regional Engineering College. Basically, now you know these colleges as NIT. So earlier NITs were called REC. So REC Srinagar, there was a problem there. Some people, Ajay Hasia and other people, complained that they had scored very good marks in the written examination, but were given very poor marks in the Viva Voce interview. And some of them claimed that we were not even given adequate chance. We were called inside the room, our names were asked, and we were said, leave. Just 1 minute of interview. It was not fair. It was violating the right to equality. So they went to court. REC Srinagar said, don't claim all these rights against us. We are not a part of state. We are a private body. We are registered under the Jammu and Kashmir Registration of Societies Act 1898. It's a private body. Don't claim all this. But Ajay Hasia and their other people claimed that REC Srinagar, which is now NIT Srinagar, was one of the 15 colleges in the country which was sponsored by Government of India. You are getting government funds. And finally, Supreme Court in this judgment also agreed that yes, you are being funded by the government. All major appointments are done by the government. So REC Srinagar is a part of state. And then Supreme Court clarified what will be those tests to check whether a body is a part of state or not. Point number 1. If a body is created by a statute, meaning a law, say Lokpal, say CVC, it is a state. Or an executive order, example Niti Aayog, CBI, example Niti Aayog, CBI, Central Legislative Commission, or let's use a more common body, NHRC, etc. They're all a part of state. Clear? Number two, if the body is substantially controlled or financed by the government. Now, what is the meaning of substantial control? How much percent? That the court has not clarified. The court says that substantial financing would mean the money the government gives to you, to your body, is so important that without that money, you will not be able to survive on a daily basis. That is called substantial financing. Are you clear? There is no exact percentage, but it simply means that the government funding is very important for your survival and day-to-day needs. That's called substantial control. Clear? Number three, if you are performing any public or sovereign function, example, police, example, armed forces, these people perform sovereign functions, ensuring the protection of the sovereignty of the country, integrity of the country, maintaining public order, law and order, etc. Excuse me. And lastly, if you enjoy government monopoly, government gives you a monopoly. For example, if today the government says that only RSS can manufacture orange colored clothes, nobody else in the country will be allowed to manufacture orange colored clothes, then insofar as that task is concerned, RSS has been given the monopoly. So RSS can be called a part of state for that task only. Or if tomorrow government says only Byjus will be the UPSC coaching institute in the country, all other coaching institutes please shut down, then Byjus will become a part of state. But right now, that's not there. Are we clear, everybody? Okay. So this is the definition of state. One very important body is not covered here. Can you observe? That body which harasses everybody, but nobody can question the body. Which body is not mentioned here? Judiciary is not covered. Are we clear? And Supreme Court has said that we are not a part of state. Please keep us out of it. Are we clear? Judiciary is not a part of state. All other examples you gave, CBI, UPSC, ED, they're all a part of state. Enforcement agencies are all a part of state. Judiciary is not. For Article 12, no, not covered. Is BCCI a part of state? BCCI, you know BCCI, right? The Board of Cricket Corruption, sorry, the Board for Control of Cricket in India, BCCI. Is BCCI a part of state? No, BCCI is not a part of state. There are two Supreme Court judgments in this regard. Z Telefilms Limited 2005 and the Cricket Association of Bihar 2015, where Supreme Court has said that functionally, financially, administratively, BCCI is not dominated by the government. It is not a part of state. Are we clear? Okay. That's it. Let's move on now. Coming to, before we discuss Article 14 or the fundamental rights, just one small topic, and then we'll move on to discuss those rights. See, the current situation in BCCI is because of Supreme Court's activism. Supreme Court has interfered to control BCCI, and Supreme Court has said that BCCI is not a part of state. We are ensuring the control of BCCI so that there is fairness. Why? Because cricket impacts the society at large, and secondly, BCCI is practically the largest body which controls cricket in the country. It enjoys an almost a monopoly, not gained by the government, but based on its own performance. So we need to regulate it. They are just regulating it, nothing else. So don't ever have the feeling, okay, that BCCI is a part of state. The government just regulates it at the behest of the Supreme Court. Are we clear on this? Okay. Now, Article 13, a very interesting article. This Article 13 was added in the Indian Constitution to ensure that the state is not allowed to make laws, and there should not be any law which continues in the country which violates any fundamental rights. Because fundamental rights were supposedly sacrosanct, very sacred. So Article 13 clause 1 says, all laws in force in the territory of India before the commencement of this constitution, all these old laws, IPC, CPC, etc., insofar as they are inconsistent with the provisions of this part. Which part are we talking about? Which part? Part 3, fundamental rights. They shall, to the extent of such inconsistency, be void, cancelled. For example, think of this. This is a law. This law has multiple provisions. Various provisions are there in this law. Now, if any provision of this law, let's say this provision, violates, is inconsistent, violates any fundamental right, this provision is automatically declared void, cancelled. It is not applicable. And if you have a problem, go to court, the court will cancel it for you. Simple. Are we clear, everybody? If there is any law which used to exist before the constitution, like say IPC, and any provision of IPC, let's say, violates any fundamental right, that provision of IPC, that provision only is cancelled. Other things are okay. Are we clear? To the extent of inconsistency. Clear? Not the entire law. Why will you cancel the entire law? Makes no sense. Are you getting my point? If your fingers are paining, you will not chop off your entire arm only and throw this arm. Useless. Of course you will not. You will solve the problem. Right? Are we clear? So this is how we have to understand it. That if there is only a small part which violates the rights, that part will not be applicable. You cannot violate fundamental rights. Second, the state also, this state shall not make any law. You are not allowed to make any kind of law which will take away or abridge. Abridge means to reduce, lessen the rights conferred by this part. Are we clear on this point? The state is not allowed to make any law which can take away your fundamental rights. And if you try to make any law which is in contravention of this clause, which goes against this clause, which violates your right, that law will be cancelled. That provision is removed. Did we understand this point? Everyone? Okay, great. I think this is very simple to understand. There should not be any law in the country, whether old or new, which should violate fundamental rights. If you make a law and that law has 10 provisions, one provision is violating any right, that provision is cancelled automatically. Are we clear? I have explained both the points together. If there is any law in the country, an old law or a new law, and that law violates any fundamental right, that law is automatically cancelled, right? And if it is not being cancelled, go to court, the court will cancel it for you. Simple. Do I need to explain further? Done? Now, when we say law, what's the meaning of law? The next clause defines law. What is law? Law would mean ordinance, law would mean order, law would mean bylaw. Bylaw is made by the panchayats and municipalities. Law would mean rules, regulations, notification, even custom in the country. If there is any custom in the country, any tradition which violates fundamental rights, that tradition is removed. You can't do this drama. It should not violate fundamental rights. Are we clear, everyone? So the state has no power only to take away your fundamental rights. It simply cannot make a law to take away your fundamental rights. Oh, we have Roshan again back in the house. Sir, notification right from day one. Notice released by the government is called notification, sir. Don't ask such meanings in the last classes. It feels very bad here that I have been putting in so much of effort. Ruchi, by law, I just mentioned, a law made by municipalities or local bodies is called a bylaw. Okay. Anyway, I think we have all agreed now that you cannot make a law to take away fundamental rights. All okay so far? Please, the story is not over because I want you to read Article 368. Read this. We all know what this is. This is the amendment to the Indian Constitution. Right? Let's read. Power of the Parliament to amend the Constitution and the procedure. We know the procedure. The procedure is the 2/3 majority, total strength 50%, all the drama is there. Ignore that. Notwithstanding anything in this Constitution. What is notwithstanding? In spite of. In spite of whatever is mentioned in the Constitution, Parliament may, in the exercise of its constituent power, the power given to it by the Constitution, Parliament can amend. What can the Parliament do? Can amend by way of addition. So Parliament can add. By way of variation, Parliament can change, modify, or repeal. What is repeal? Remove. Parliament can add, Parliament can change, Parliament can repeal. Please read. Any provision. Any provision. Any provision means what? Part 3 also. Yes or no? Any provision can be removed. What the hell is this? This is complete contradiction to what we are studying here. You are saying that you can't make a law to take away rights. But Article 368 says, no, wait. Whatever is mentioned here, to hell with all that. The Parliament can remove anything. Does it also mean that the Parliament can remove fundamental rights? That's a big concern, right? It's a very big problem actually. So this was the conflict, that one article is saying you can't take away rights. The other article is saying, no, you can amend everything. Now, the center wanted to go for land reforms. And when it comes to land reforms, the idea that was being propagated was that take land from rich and give to poor people. So back in those days, these rich zamindars owned hundreds of acres of land, right? And on this land, there were people who were acting as tenants, farmers who had no control, no ownership. For generations, these people were acting as tenants only, working for the rich zamindar, right? Government said, we will have to take this land away from you. Why do you need 100 acres of land? Take the land away and give to poor people. Make the tenants permanent owners. But when you are taking away somebody's property, you are violating the fundamental right to property. Back in 1950s and 60s, the right to property used to be a fundamental right. It was under Article 19. It was getting violated. The problem is now how to do it. Government came up with a simple solution. Government said, wait. What can we not do? We can't make a law, right? You cannot make a law to take away rights. And law means all these things. I am not making a law. I am amending the constitution. What I am doing is, I am doing an amendment. Amendments are allowed because this word amendment is not mentioned here. And Parliament passed the First Amendment Act of 1951 to allow the Parliament to take away land from the rich people. Did you understand this point? The Parliament said that, see, you are saying that Article 13 Clause 2 says we can't make a law. We are not making a law. We are making an amendment. And amendment is not a law. Is it a law? It is not mentioned here. Please cross-check yourself. I'm not lying. Amendment word is not used here. So we are amending the constitution. Are we clear? So this play of words happened. This matter, Soyab, I did not understand your question only. How many laws would be made for one fundamental right? Is there any limit? I have no idea what you are asking actually. So please rephrase the question. Make it more logical and sensible. Did you understand so far? Of course, the zamindars were very upset. Zamindars were very, very upset. They ran to the court immediately. What is this nonsense? But amendment is also a law, right? What is amendment? When you modify the constitution, is that not applicable on the people like a law is? What's the difference? Just because the word amendment is not mentioned, can you make this kind of nonsense? So they went to court. But the court said, wait. Sorry. The Parliament is right. Amendment is not mentioned and amendments can be done. And in the Shankari Prasad case, the Parliament very clearly said that zamindars, fundamental rights are amendable. Whether you are liking this approach or not, the government is right. Fundamental rights are amendable. And interestingly, the Supreme Court held this opinion. Zamindars used to run to court that court, please save me. My property has been taken away by the government. The court said, sorry, the Parliament has amended the constitution. Article 368 says, in spite of whatever is mentioned anywhere, the Parliament can repeal, modify, add any provision. Fundamental rights are amendable. Don't be a crybaby. Get lost. This was being done. Are we clear so far? But then back in 1960s, a very interesting thing happened. There was a case called Sajjan Singh case, Soya BS, any number of times. There was an interesting case called Sajjan Singh versus State of Rajasthan. In this case, the Supreme Court gave the same judgment. But one judge, Justice Mudholkar, raised a concern. Justice Janardhan Raghunath Mudholkar. He asked a question that we are allowing the parliament to amend everything. Is that appropriate? Should there not be some limitation on the parliament's power to modify things? I mean, if you allow the parliament to amend everything, what if tomorrow they amend the democratic nature only? Other judges said, sir, you please relax. Don't disturb this right now. The topic is on whether parliament can take away the land of the zamindar or not. Don't confuse us. So his point was observed but not taken too seriously. In fact, just a couple of years back in the Pakistan Supreme Court, in the Fazlul Qadir Chaudhary case, 1963, the Pakistan Supreme Court had given a similar kind of observation that you cannot, the state cannot claim everything. Limitation on the power of state. And if you remember, in the Berubari Union, the Supreme Court said the same thing. Article 3 does not allow the parliament to do everything. There are limitations on the parliament. So everybody was talking on some limitations on the parliament. But the ultimate judgment was the same, that rights are amendable. Finally, in 1967, judgment came, the Golaknath case. This judgment completely reversed what the court was saying. An 11-judge bench, 11-judge bench together claimed that what? Fundamental rights are sacrosanct. How dare you amend the fundamental rights? They are not amendable. This judgment is very interesting because this Golaknath, who is Golaknath? Golaknath were two brothers, William and Henry Golaknath, and that was their name. These people in Punjab, they owned around 500 acres of land. 500 acres of land. And the government took all their land, took 88% of their land, and told these Golaknath brothers, William, take 30 acres. Henry, 30 acres. Go enjoy. Imagine you have 500 crore rupees and that money is taken by government and government says keep 30 crore each, go, get lost. Of course they are upset. They had gone to court. So basically what used to happen was that the government had some kind of list, a list comprising of names of all the zamindars whose land was slowly and steadily being taken away. Whenever any zamindar's land was taken away, he would run to court. That court, please, my land has been taken away. And what would happen? The court would always say, please leave. But finally, when Golaknath went to court, the Supreme Court said, no. Rights can't be amended. Government is very unhappy. They're going back crying. Golaknath is parting that, yes, my land is saved. But court said, wait, Golaknath, don't be happy. What has happened so far has happened. Your land is gone. Sorry. From this date onwards, the rights will not be amendable. So Golaknath also went out crying only. Both the parties were upset. Unique kind of judgment. Anyway, let's take a quick breakfast break And once we come back at 9:35, we'll take up for discussion what happened after this. Because Supreme Court took a panga with Indira Gandhi. So what happened when Supreme Court tried to take on the might of Indira Gandhi by putting a restriction on the government from amending the constitution? Let's take a break. Be back at 9:35 and we'll continue our discussion further. Okay, so interval time. Mayank Vadvani, sir, what are you asking, sir? Why this question, sir? Law and Act. We discussed in the very first class, sir. Act, a bill passed by Parliament is called an act. When it is notified by the government, published in the Gazette, it becomes a law. Guys, I'll address the right to property problem, but let's come after the break. Don't worry, the story is not over. It's incomplete. The climax is left. Break, please.